Good afternoon, everyone. I'm Mike Strozinski, Executive Vice President and General Counsel at the Massachusetts Health and Hospital Association. On behalf of the entire team here at MHA, I want to welcome you to today's webinar, Steward Health Care Bankruptcy Update, Part 2, continuing the conversation and updates on the sale process. A few housekeeping items before we begin. If you have questions during the webinar, you can enter them into the chat feature as we are in a listen-only mode. The questions will come directly to us, and we'll do the best as we can to get to all of them prior to the end of the presentation. I also want to thank MHA's 2024 annual sponsors and strategic business partners for their support in underwriting today's webinar, which is just one of numerous events we offer throughout the year to keep the healthcare community up to date on the most timely important topics. And when it comes to topics weighing heavily on the minds of local providers and patients, I think perhaps none are higher on that list than the future of the Steward healthcare system. MHA and our members are continuing to work closely with state officials and partners across the sector to track the Steward bankruptcy and respond to its local impacts, including the 2 planned closures at Kearney and Neshoba Valley that Steward announced last Friday. While we're still waiting to learn more about the bids for Steward's other local hospitals, we thought it'd be a good time to bring back our outside experts to cover how this process may continue to unfold. With that, I'm happy to reintroduce our speakers from Manatt, Phelps Phillips, Eric Gold, and Schuyler Carroll. Eric is a healthcare partner and leader of Manatt's Boston offices. His expertise lies in government and internal investigations, state regulatory matters, and health policy engagement. He uses this experience to advise public and private clients on issues involving healthcare access, insurance coverage, behavioral health, and more. Prior to his current role, Eric served as chief of the healthcare division at the Massachusetts Attorney General's office, where, amongst many other major accomplishments, he played a key role in major litigation efforts to prevent federal health policy rollbacks that would limit Massachusetts residents' access to coverage. Schuyler is a partner at Manatt, Phelps Phillips, who specializes in guiding clients through complex bankruptcy proceedings. Primarily focusing on Chapter 11, 15, and 17 cases, Schuyler provides solutions and litigation support for bankruptcy, restructuring, transactional matters, distress acquisitions, and creditors' rights enforcement. It represents a variety of clients, including debtors, creditor committees, and claims traders. Schuyler also has extensive experience in state and federal courts, litigating creditors' rights, enforcement actions, and fraud claims. Both Eric and Schuyler joined us for part 1 of this continuing webinar series back in late June, and ended up being one of MHA's most well-attended events on record. And I know today has drawn another large audience. So thank you both for joining us again, and I'll hand it over to you to get us going.
Thanks, Mike, and thanks to everyone at MHA and everyone listening for inviting us back. We're pleased to be able to share some updates about what's going on with the Steward healthcare bankruptcy and in the subsequent regulatory process. I think we can go to the next slide. And here's sort of what we'll cover today. I will start with some quick updates on the bankruptcy overview and the hospital operations of Steward. Schuyler will walk through then the proposed closure of the Massachusetts hospitals and the proposed payment from the Commonwealth, a $30 million payment that you may have read about that'll be heard this week. And then he'll talk about the proposed sale of the 6 Massachusetts hospitals in the Steward Physician Group. And then it'll be back to me to talk about the post-approval regulatory process and the DOJ and Senate investigations that you may have also read about. And we'll have time for some questions at the end. We can go to the next slide. So just to recap, and I'm sure you're all familiar with this, in May, Steward filed for Chapter 11 bankruptcy protection in the bankruptcy court in Houston to obtain time to sell its hospitals and its physician group. At the time, Steward owned and operated what it described as the largest private physician-owned for-profit health system in the United States that included 31 hospitals in 8 states, 4,500 affiliated physicians, 3,600 beds, and nearly 30,000 employees. In terms of what's going on with a bankruptcy for other states, as I said, Steward is trying to sell its hospitals across the country, all 31 of them. In Ohio and Pennsylvania, Steward found no bidders for its hospitals and canceled the auctions in those states. Steward has sought approval to sell one of its hospitals in Louisiana, Glenwood Regional Medical Center, for $500,000, and also sought approval to sell its hospital in Arkansas, the Wadley Regional Medical Center, for about $200,000. So those requests are pending. to just to give you a sense of what's going on with other hospitals in other states. Various other state auctions, including Florida and Arizona, our processes are ongoing. The next slide. So in terms of the Massachusetts hospital operations, at least, from public reports from the press and from the State Department of Health, and I know this is something that MHA and its members have been following closely, have reflected significant declines in the inpatient volume at the Steward hospitals, starting just from January to June 2024. 40% inpatient declines at Kearney, 36% at Holy Family, 35% at Neshoba, and 30% at St. Elizabeth's over this 6-month period. In June, the state has reported that Kearney's average inpatient census was 13 people, 13 beds filled. Neshoba average inpatient census was 11. They're out of 83 medical beds at the Kearney and 46 at Neshoba. So obviously a clear trend of patients moving away from the Steward hospitals, which is relevant and will have some effect on the overall how the hospitals will be transitioned away from Steward. We can go to the next slide. So in terms of the hospital facilities and ensuring safe and adequate care of the patients, we talked last time about a patient care ombudsman. Here in this case, actually two women who were appointed by the United States trustee to monitor patient care and safety issues in hospitals across the country. And they have filed their first set of what are to be reports every 60 days with the bankruptcy court on July 21st. So the patient care ombudsman for Massachusetts filed detailed reports on each of Steward's 8 hospitals. The overall conclusion was that the ombudsman did not observe any material issues impacting patient care that required the court's immediate attention. But there were lots of details, including some areas of concern and some problems that were identified. They largely related to the facilities and equipment that was in need of repair or replacement. That included kitchen equipment. In one of the reports about St. Elizabeth's, there were sort of detailed reports about concerns with the elevators, including the elevators in the parking garage, but other concerns about endoscopy scopes and hospital chillers. I understand that to be the air conditioning systems in the hospital, which are obviously important. So I think this trend may have what motivated the governor and the Department of Public Health to continue pushing for the sales of the hospitals. So with that, I'll hand it over to Schuyler to talk about the pending motions.
Thank you, Eric. Good afternoon, everyone. So the motions that the debtors have filed, actually, let me just take a quick step back. When we were here last, we had a schedule that would have taken us to today with approval already for the sales. The debtors have pushed that schedule back. And now to flip to the bottom of this page, you will see that the current schedule is for a hearing tomorrow to consider closure of the 2 hospitals, as well as the payment agreement that Massachusetts has offered. And I'll talk about both of those things further. And then a sale hearing on August 13th. So this is, by my count, I think the 3rd time these have moved back, which is a little bit unusual in bankruptcy. It does happen, but doesn't happen all the time. So more specifically, the debtors have filed papers that indicate they want to close 2 of the hospitals, Kearney and Neshoba Valley, and that they want to sell 6 others. They are still, or I should say the other 6 in Massachusetts. They are still in negotiations with parties they describe as high quality local operators who have provided bids for those 6 hospitals. Unfortunately, we don't have any other information about those 6 hospitals and the bidders. Although we do know some information that I'll talk about with respect to the leases. Talk about that in a minute. With respect to the Stewardship Health process, they have announced that the prior offer from Optum Health has been withdrawn. You may recall that there were antitrust issues raised, among others, by Senator Warren about that. That may have been one of the reasons. Again, we don't have any further information about that. And that they have not yet received any qualifying bid for the purchase of Stewardship Health. They are continuing to work on that, however. Next slide, please. The proposed closure of the 2 hospitals, as I mentioned, Neshoba and Karn, the debtors have filed a motion to approve that. The hearing on that motion is tomorrow. At that motion, it appears that the debtor may present witnesses, their chief medical officer, chief restructuring officer. And for those of you not familiar with the process, in a bankruptcy of this size, it's not unusual for a third-party advisor to come on. You might have heard some of these names before, for example, Alex Partners or Alvarez and Marcel. Those are 2 of the bigger names. They do this often, and they bring operational support and also financial support, specifically with respect to what is needed in a bankruptcy. And in cases like this, it's often the case that one of the leaders of that advisory group is appointed as an officer of the company, the chief restructuring officer. That's what happened here. And in this case, I should say the CRO, as we often refer to them, is actually someone who was on the board previously, but they do have outside advisors as well. In any event, those parties may testify, and if anyone objects, they may also cross-examine those witnesses. The hearing will be with respect to the closure plan. I don't expect that the court will get involved specifically with the details of the closure plan, but the court will want to see what the debtors have already filed, that they do have a closure plan in place, and hopefully that no one is objecting to either the closure itself or the closure plan. If no one objects, and obviously the state and regulators have been very involved in this process, so if they were to object, the court would be very interested in their objection. But in addition, the lack of an objection is something the court will take into account and likely approve it. In fact, I wouldn't be surprised, as long as there are no objections from the state or local regulators, that the court approves it, even if somebody else objects. 2 other points that are being heard at tomorrow's hearing. One is rejection of the master lease. That's with MPT and Macquarie. Again, you may recall the property, the real estate itself is not owned by Steward, but by MTT Macquarie. The terms of the lease are significantly above the market, so the debtors seek to reject that lease. Talk a little bit more about that in a second. And the other thing is to allow the debtors to enter into a payment agreement pursuant to which the Commonwealth will make advances to the hospitals to allow them to continue operating. Next slide, please. The court is very likely to approve the closures, particularly if Steward has a sound business justification. The papers have talked in detail about the sale process, about the lack of income, or to say it differently, the money that they have been losing, not only before the bankruptcy, but after the bankruptcy. And I suspect based on that, the court will approve it. The standard for approval is generally very deferential to the company in bankruptcy. Other parties might object, but as I mentioned, unless it is one of the regulators, I don't think the court will believe their objection and will overrule their objection. Next slide, please. The rejection of the master leases is also something that the court is likely to approve, and also something that bankruptcy courts give great deference to the company's thoughts, and if no one else objects, is certainly likely to approve. Even if a party objects, and even if the landlord objects, I suspect the court will approve. The standard is favorable to the debtor. In this case, there's no question that the lease payments are significantly higher than current market rates. And there's two parts of that evidence. First is every bidder that has made an offer for any of the hospitals has asked for significant rent concessions or to purchase the real property, and to do so at a significant discount. The second is the debtors have gone out to the market and have actually found what they believe are the current market rates for similar properties. Obviously, there aren't a whole lot of comparables, but they believe that they are significantly above market rates. Because of that, it's highly likely that the court will approve the rejection. Next slide, please. The one other point that is relevant to the rejection is that the operators who have made bids, none of them have offered to take on the current lease payment. The other points in this slide we already talked about. So next one, please. Next slide, please. Sorry. So the proposed payment from the Commonwealth, they are proposing to pay for operating expenses to allow the hospitals to continue operating until a sale can be finalized. It's $30 million in total. The payments are broken up, $15 million on August 1st and $15 million on August 15th. The payments are essentially advanced payments or interim payments from the acute hospital rate year of 2024 that would have otherwise been made in July, August, and September. The payments are only to be used for working capital, patient care, and employee salaries. It can't be used for executive payments, can't be used for professional fees or closure costs, and it can't be used for payments to other creditors. Next slide, please. As to the closure, Steward has indicated that they received no qualified bids for Kearney or Neshoba. And I should highlight the word qualified there. It may be that they received bids, but that either operationally or financially, those bidders were not deemed to be qualified, or it could be that they didn't offer significant payments and they therefore decided that closure would be better. The last part of it is something that would be typical in a non-hospital bankruptcy, but I suspect that if they did find any bidder who was able to financially and operationally take on the responsibility of continuing the hospitals, they would have accepted that bidder, even if the purchase price was minimal or frankly zero. Steward says that the closure should happen by the end of August 31st. They'll form a command center to oversee the closure and make sure it's done appropriately, orderly, safe. They'll provide notice to the employees, allow some of them to transfer other hospitals. They'll negotiate with the unions to facilitate the hiring at other hospitals. They will discharge and transfer patients to other hospitals or outside of hospitals, and they will store patient medical records. That's obviously something that is of concern outside of bankruptcy, but bankruptcy courts also recognize the importance of it and will require that the debtors do that in an orderly and protective fashion. Next slide, please. And now, again, some of these things we talked about, so I'll just go through it quickly. They've reported they have high quality local operators who have bid for each of the hospitals. Specific negotiations are continuing. End of June, they announced that Optum withdrew its bid. The press indicated Steward cited a challenging review process with the DOJ. Right now, there is no stalking horse. There's no other public information available right now. Next slide, and with that, I will turn it back to Eric.
Thanks, Schuyler. So you've heard what's going on in the bankruptcy. So here I want to just talk about what will happen outside the bankruptcy, first with the closure and then with the sales. And there's been some questions around this. So the hospital closure, as Schuyler said, Steward seeks to close the Kearney and Neshoba Valley in 30 days. The timeline that they've laid out here is on the right-hand side of the slide. They propose to provide a formal closure notice promptly, that within 15 days in advance, they would post the notice literally on the doors of the hospital, stop any elective inpatient admissions. They propose to have a public hearing 8 days before the end of the month, and then 5 days prior that DPH would determine closure was appropriate, and that the day before they would close the emergency department and completing discharge of patients. All the while, sort of over this month, work to identify alternative locations for patients and discharge patients as appropriate. As you can see on the left side of the slide, I include what is the standard regulatory timeline under a DPH essential services closure notice, and that's an 120-day process with a public hearing 60 days out, a 45-day essential service determination, and then a plan from the hospital for maintaining access, and then a sort of back and forth with DPH over those last 30 days. Obviously, 30 days is a lot shorter than 120 days. Steward has asked the court and told the court that longer than 30 days will not promote patient safety. They claim that it will raise safety concerns because their staff will begin to depart, and that beyond 30 days they might be maybe insufficiently staffed. So it'll be up to the bankruptcy court to determine whether to allow the closure as quickly as 30 days. You can imagine there might be some compromise reached, although at least as of this morning or an hour or so ago, there was not an objection yet to the 30-day closure proposal. It's worth noting, and I've highlighted this below because DPH highlights it on its website, that even outside of the bankruptcy, even under the normal regulatory timeline, the state can't legally require a hospital to keep a service open, right? They can effectively require or try to require someone to meet the 120-day standard and meet the regulation. But the way they do that is through sort of licensure, sort of enforcing the license. So when a hospital is leaving the state entirely, it's not much of a threat to say that we're going to take away your license or prevent you from opening other new services or the like. So they'll be lots of conversation around this at the hearing on Wednesday, I imagine. Okay, next slide. So, and then the other conversations then that will be happening are about the change of ownership. And you heard the governor, I've quoted this on the bottom of the slide, say last week when Steward announced the closure of the 2 hospitals and that it had found bidders that Steward should finalize these deals quickly. I think as we understand the proposal with the Commonwealth's funding, the goal is to have these hospitals transferred to new owners by the end of August. So this is really compressing into 30 days, what is normally this much longer regulatory process around change of ownership. And this is the slide that I went through last time in June, where you can see in the normal course, there are 3 different regulatory agencies that are reviewing and commenting on, or potentially commenting on, a proposed hospital ownership change. I guess starting on the right with maybe what's going to have the least involvement here, the Attorney General is normally reviewing and considering antitrust implications to potential owners. Presumably they will do that here, but they're going to need to do it on a very expedited basis, and it would be quite surprising in the context where the governor and others are demanding that these sales go forward for the Attorney General to sue to block one of these acquisitions. Similarly, the Health Policy Commission, right, normally requires a material change notice to be filed 60 days before any major transaction. The HPC can then elect, if it wants, to conduct a cost and market impact review, which will go on, which could go on for months or even more than a year. Again, it seems highly unlikely here that HPC would exercise its authority to conduct that type of lengthy review. It is worth noting, though, even when HPC does this, there's not a process or a means for them to enforce that is the sort of hold on the transaction. What is maybe most important and most significant here is Department of Public Health, right? Through what is the part of the determination of need process, any change of ownership needs to petition DPH, and ultimately the Public Health Council has to approve the transfer of the hospital license, right? And any new operator of any of the 6 Steward hospitals will need to be licensed to operate that hospital, and DPH will need to approve it. So presumably the DPH, with the sort of at Steward's request and at the request of the new operators, and because it wants to see continuation of services here, will try to move very quickly. And although we do not know who the bidders are for these new hospitals, I presume the Department of Public Health already knows, and they are starting that process even while the details of the new contracts are being negotiated. They are starting that process to assess the new operators and move forward, and what will be a quite expedited, I would expect, review of a determination of need application and an approval by the Public Health Council. So the next slide. So that's sort of where we are on the sale and closure process, and we have some questions about that, and we can get to those in a minute or two. I did just want to note 2 things that are sort of happening in the background, and I don't think have a direct impact on the sale process, but are at least worth knowing about. And the first is this Department of Justice investigation. So Steward has publicly acknowledged, following press reports, that the Department of Justice is conducting an investigation under the Foreign Corrupt Practices Act, which prohibits bribes to foreign government officials. The suggestion in the press has been that this is related to Steward's business dealings in Malta, where the government there brought charges against several former Maltese government officials earlier this year, alleging that they had solicited bribes from Steward related to a hospital that it was seeking to build there. Under the Foreign Corrupt Practices Act, the Department of Justice can investigate and then prosecute individuals who pay bribes to foreign governments related to business in those outside the United States. In terms of its relevance to the bankruptcy, the U.S. government, to the extent that it may obtain criminal fines and penalties from Steward, may have priority over other claimants. The claimants here are chiefly the lenders, the banks and hedge funds and MPT who have lent money to Steward in recent years, but also all of the vendors and employees and others who may have been owed back pay and monies over the years. So the U.S. government may take priority. And while it's possible that the criminal investigation resolution could delay confirmation of the bankruptcy plan, ultimately, as I said, it shouldn't slow the process to sell the hospitals or the physician groups in the coming weeks. And next slide. The other national investigation that you probably have read about is the U.S. Senate investigation. The Committee on Health, Education, Labor, and Pensions, known as the Health Committee, launched an investigation of Steward and issued a subpoena to its CEO last week. These were both bipartisan votes. 20 votes were 20-1 to start the investigation and 16-4 to issue a subpoena. As reported by the committee, this was the first subpoena that Senate Help has issued in more than 40 years, since 1981. It seeks testimony of Dr. De La Torre at a hearing on September 12th to be titled "Examining the Bankruptcy of Steward Health Care: How Management Decisions Have Impacted Patient Care." Again, this is the type of thing that is really in the background, unlikely to directly affect the hospital or physician group sales, but the investigation and the facts that come out of it and that are made public may influence potential claims that creditors or even the debtor itself may have against the CEO or others. So it's an important point to continue to watch. So we can go to the next slide, which I think is question and answer, and we've received lots of questions in the chat. So thanks everyone for doing that. I'll invite Schuyler to come back on camera. One question that came in earlier that I think I've looked up, there was a question about the sale of the hospitals in Louisiana and Arkansas, and as to whether those sales were purchases of the facility as well from MPT, or whether they were leases. And it seems like they are, having looked, that there's one of each. In one of the purchases, the individual hospital purchased the building as well, purchased the real estate. And in the other one, they seem to have signed a new lease with MPT. So that's the answer to that.
And Eric, just one thing quickly, in addition to the filings we talked about, there was an objection filed late yesterday by the creditors committee to the payment agreement from the Commonwealth. And it essentially says that they support the agreement, but they have some specific problems with the terms. In particular, I'll just highlight two of them. One is that the Commonwealth, if they pay the money, is entitled to recoup the money back from the hospitals at any time without going to court. That's a little unusual in bankruptcy. So they're asking for the recoupment to only be after court approval. And the second is that only the only the 6 debtors that operate the Massachusetts hospitals, which are going to be sold, are receiving the money, but the creditors committee complains that all of the debtors are jointly and severally liable if the Commonwealth wants to get the money back. In that situation, it's not unusual for the parties to be able to resolve those issues before the hearing. So I wouldn't be surprised if that happens here. Going back to some of the questions, I saw there was one about, does the bankruptcy court have to approve the sale price? The court doesn't specifically approve the price, but the court does approve the sale and the process more generally. So the distinction there is, and this actually answers another question, steward gets to choose in consultation with the lenders, the creditors committee, and other major constituents in the bankruptcy case. Steward gets to choose who they believe is the highest and best bidder, goes to court seeking approval. Any party in the bankruptcy can object to that. A potential bidder who wasn't the highest could potentially object, but courts generally don't give much thought to objections from other bidders. And courts recognize that there are a lot of issues other than a disgruntled bidder saying, hey, wait a second, they were paying $1 and I'm willing to pay $2. A lot more that goes into an actual purchase than that simple argument, which is typically what you hear from a disgruntled bidder.
Thanks, Schuyler. There were several questions about many about the closure process, and I think I talked some about that, but just to make clear that there will be a court hearing tomorrow, 1 o'clock Central, that folks can follow, where the judge will determine how fast Steward is going to be permitted to close the Kearney and Neshoba Valley hospitals. So I think it's theoretically possible that the judge could tell Steward they have to keep it open for longer than 30 days. But Steward has basically said that they're out of money and that every day they operate those hospitals, they're losing money, and that they are that the safest way to care for the patients is to close the hospitals in an orderly way over the next 30 days. So there was a question about who might have standing to object. Any of the creditors have standing to object. So there's a long list of folks who have the capacity to do that, and I expect we'll see some objections. There will be an opportunity for lawyers to cross-examine the Steward witnesses at the hearing tomorrow. But that'll be the process for the court to determine the exact timing. It's not clear if the Commonwealth will object to that closure schedule. Steward has suggested that the Commonwealth will not, but I wouldn't be surprised to see a response by DPH, at least suggesting that they believe Steward can be and should be doing more to facilitate the orderly closure of those facilities.
Another question, Eric, was for the hospitals that are being sold, will MPT surrender the real property? No, they're not going to surrender, but the bidders and Steward are in negotiations now with MPT to try and reach agreement. And more broadly, and the agreement would be either on reduced rental or a potential purchase of the real estate. And more broadly, there has been a mediation scheduled with another bankruptcy judge to act as a mediator. Mediation is a voluntary process where a third party, in this case, another bankruptcy judge, acts as the mediator, trying to persuade each side to come closer to an agreement and ultimately reach an agreement. Call it shuttle diplomacy, if you will. And bankruptcy courts often ask parties, sometimes force parties, to engage in mediation. And it is very often done in Houston. It is very often done with the judge who has been appointed as a mediator. I've been involved in probably a dozen mediations with him as the mediator. So hopefully that will ultimately result in some agreement.
There are lots of questions. Trying to find a good one. Lots of good questions. I guess trying to find one that I can answer quickly. So there's a question about DOI is putting out a bulletin or suggesting that DOI may be putting out a bulletin advising carriers how to protect patients and who might be looking out for Medicare Advantage patients, Mass Health patients, those without insurance. I think there would be the other regulatory agencies who oversee those other types of insurance, right? As folks know, the Division of Insurance oversees all the state regulated health plans. The EOHHS oversees Mass Health and is quite concerned about Mass Health members. The federal government, CMS, oversees Medicare and Medicare Advantage, and the Department of Labor, EBSA, oversees the self-funded ERISA plans. So each of those agencies, for better or worse, the health insurance regulatory oversight is quite fractured, and those different agencies will be overseeing and watching out for members of each of those types of health plans.
There is a question about the proofs of claim. Unfortunately, it is not unusual for this kind of thing to be confusing to lay people. It is with regard to a malpractice claim, those would likely not be affected by the bankruptcy because most of those are going to be covered by insurance. I certainly don't want anybody to take those statements to mean they don't have to do anything, but in most cases, patients will be protected. If you know of someone who has a claim, they should definitely assert that claim and also attempt to get assurance that the bankruptcy will not prohibit them from pursuing insurance. Any other particular questions? Unfortunately, it is a complex process, so it can be difficult for folks. Question about malpractice tail coverage. I don't yet know the answer to that, but I suspect it will be something that all of the doctors will be pushing for. So I would suspect that it will be covered in most cases, even where a hospital closes. That is something that the company does make sure gets paid for. There's a question about the relationship between Steward and MPT. We can't say for sure, but there hasn't been any allegation that there is anything other than an arm's length relationship. MPT is one of the largest healthcare landlords in the country. If I remember correctly, they are a publicly traded REIT, and they have been involved in a whole lot of hospital bankruptcies. I haven't seen any situations where they have a relationship with another operator. And again, there's not been any suggestion here that they are related to Steward. And there was, at the beginning of this case, an agreement to provide, for MPT to provide financing that certainly would have caused the creditors committee to look into whether there was any relationship. I don't know for sure that they did, but again, there was no allegation that there is.
So there's a good question about asking about the identity of the bidders for the 6 continuing to operate hospitals, and whether the same sort of attorney general concerns about size and organization and monopolies are still is in existence here. And I think the short answer is that we don't know anything about the bidders. At least I don't know anything. Maybe others do. But that and the antitrust laws still apply. But the antitrust laws do have an important sort of component, sometimes framed as an exception for what are called failing firms. So where it is the case that the business, any business, including a hospital, a nonprofit hospital, or for-profit hospital, would fail if not for the firm that is bidding to keep it operated, then that's usually a defense to any antitrust, to an antitrust claim. And the idea there is that, right, the antitrust laws are trying to promote competition, and if a hospital goes out of business completely, that does not help competition. But even if a business that has lots of market share can acquire it, that's better than no options for consumers. So I think it's likely here because it seems like, if there were not a lot of interest in these hospitals, and certainly they are in bankruptcy, they are not doing well financially, that there will be less antitrust scrutiny than there would be otherwise. Although you could imagine if there were two bidders for a particular hospital and Steward had selected one that had much higher market share than the one with much lower market share, might complain to the Attorney General, and the Attorney General might decide that they have to move forward. But I think that would be highly unlikely in this circumstance. I think we're close to time, if not at time. Mike, I don't know if there are any of these questions that you think we should definitely take a minute to answer, but there are a lot of good ones.
Yeah, we got, as long as you guys are good, we got a couple more minutes we can go here. Okay. I saw employee pensions popped up a couple of times here, particularly for those in the hospitals. If the court approves the closure of those two hospitals, how does the employee pension picture play out?
In a bankruptcy, if we have union pension plans, the union will likely have a withdrawal liability claim. The claim may or may not receive any payment in bankruptcy. It also may receive PBGC benefits. Typically, that means the union employees may still receive their pension, but there wouldn't be any further contributions going forward. That's a question that really relates specifically to each pension fund. With respect to non-union employees, again, for the closed hospitals, there likely would not be any further contributions, but the pension, to the extent it is administered by a third party, should still continue, and distributions in the future should be, to the extent there is funding available. For hospitals that are continuing, in those instances, the purchaser will likely negotiate with both union and non-union employees to address those issues. I suspect in today's market, the employees are going to have a bit more leverage there to say you need to continue the full pension plans, otherwise we're not going to continue working for you. But that certainly changes, and it's hard to predict the future on those, but it's not really a bankruptcy question.
I'll try to roll up a couple of these questions into one. So with the closure notice, if the court approves, how does that play out practically, right? At the end of the day, it's really no benefit to the creditors other than sort of relieving Steward of the ongoing expense of running those two hospitals. Macquarie MPT still own those two hospitals. What does that mean practically moving forward, other than the fact that the two hospitals will likely close?
Yeah, I mean, I think so. Over the next month, right, it's going to be DPH working very closely probably with you, Mike, and others at MHA to ensure an orderly closure. And then afterwards, you're going to have two buildings, and one in Ayer and one in Dorchester, that are owned by these firms that can be used for other purposes, right? That sort of the licenses will be revoked or voided. It reminds me in some respect, I don't think it's much different. When I was at the state, we had the situation with, it's happened a lot since, nursing home closures, right? We had, I was involved with the receiverships of the Skyline nursing homes throughout Southeastern Mass, and those closed, and then the owners had to find other uses for the facilities. In some locations that happened very quickly, and others less quickly.
One that's come up, I know, throughout this process is sort of Medicare, Medicaid, successor liability, right? You have potential purchasers or leases for these properties entering into these agreements without knowing sort of if there's CMS liability at that facility that they're interested in. How does that tend to play out? I mean, I've had hospitals ask us here of, you know, whether CMS can step in and sort of waive that liability. It does not seem like there's any precedent for that nationally. Are there any protections against what is somewhat of a black box for those hospitals looking to step in and assume the leases are purchased now?
I have seen some instances where not CMS, but the state has agreed not to seek recovery going forward from that liability. That can happen. It is not something the bankruptcy court can impose, but I have seen it where they have agreed.
In Mike, you might have been referring here. I mean, we did see here the in the sale or the proposed sale of the Louisiana and Arkansas hospitals, they sought, at least as alleged by the United States, they sought to limit future Medicare and Medicaid liabilities, and the United States has filed an objection to those provisions in the agreements. I believe the approval of those sales is also scheduled to be heard tomorrow. Admittedly, I've not been following the Louisiana and Arkansas proceedings as closely, but I think so. You might see, if you follow the hearing tomorrow, some conversation about whether there will be protections from liability in those other cases.
So I'm just panning through to see if we've got any other common themes here. Is this in? I think you both addressed this. Has come up in several questions, though. If the court approves the closure, the state is somewhat handcuffed here, right? And its ability to push back against that.
Yeah, I mean, that's right. I mean, again, the state, even under state law, cannot force any hospital to stay open forever, right? The best they could do is try to enforce the 120-day, notice period. Sorry, my internet cut off for a second there. The last time the state tried to do this was in the North Adams Regional Hospital, where they tried to they tried to close on 48 hours notice. The state tried to get it to be longer, and even that was not especially successful. So I think that the state might push for a longer runway here than 30 days, but ultimately will work with DPH or work with Steward to ensure a safe closure.
Right. And I guess maybe final one for Schuyler. I mean, is there a likelihood or possibility that this could get pushed beyond even August 13th at this point?
Yes, definitely. And in fact, I take from the structure of the payment agreement that provides for payment on August 1st and August 15th, that there might be some pushing back after August 13th. Could be maybe another couple weeks after that, but at a certain point, there's no money left, so you can't just go forever like this.
Well, thank you both for joining us here today, and I'm sorry if we weren't able to get to some folks' questions here, but I anticipate there may be a demand for a third in this series, and so we will talk to Eric and Schuyler about that and make sure you're all aware if we're able to pull that together. once some additional information is available. Today's slides will be available in the recording and will be circulated to those who registered for the event. So I know we've got a lot of questions on that front. And again, Eric, Schuyler, thank you so much for joining us and sharing your expertise yet again. We at MHA will continue to provide updates to our members and the public as we can on this issue, and we greatly appreciate your guidance. Thank you for joining us, and thank you all watching for joining us today. We got a number of additional events coming up in the near future, and in particular, I'd like to point out September's Substance Use and Harm Reduction Conference, where we'll explore the challenges and models for supporting the health of our communities. Encourage you all to attend that one. You can scan the QR code on the screen here to see all of MHA's educational programming in the months ahead. And please visit mhalink.org to learn even more. Thank you all for joining us. Eric, Schuyler, thank you again. Hope you all have a wonderful afternoon.
Thank you.
Thank you.